The Supreme Court just dropped a decision that hit the gun rights world like a flashbang, 8-1. That's how the justices ruled in an emergency decision that completely rewired how this country's going to look at state-level Second Amendment protections moving forward, and the only one standing with Missouri was Justice Clarence Thomas. Now here's where it gets wild. While everyone was expecting full support from the Trump administration, what came next was a legal move so unexpected, so tactical. It's got both sides rethinking the entire battleground between state authority and federal gun control. You're gonna want to sit tight for this one, because the fallout isn't over. It's just getting started. So make sure you hit that subscribe button and stay locked in, because what's coming next could shift the Second Amendment fight in all 50 states. The September 29th Conference. Coming up on September 29th, the Supreme Court's going behind closed doors for a high-stakes conference that could decide the future of every state-level gun rights law in America. This isn't a public hearing. It's private, strategic, and critical. That's when all 9 justices sit down to decide if they'll take up Missouri's challenge to the lower court, ruling that struck down its Second Amendment Preservation Act. Now here's the tactical detail that matters. It only takes 4 justices to greenlight full review, oral arguments, and, eventually, a final decision. But Missouri's already fighting uphill, because in that earlier 8-1 denial for emergency relief, only Clarence Thomas stood in their corner. And here's the twist. The Trump administration just filed a response that basically hands the court a clean exit. They're signaling a willingness to concede certain parts of the case, giving the justices the option to dodge it entirely and let the lower court ruling stand. But Missouri's not letting that slide. Their legal team fired back, warning that if the Supreme Court ducks this fight, it leaves the Eighth Circuit's dangerous precedent in place, which could end up undermining gun rights legislation far beyond Missouri's borders. Missouri fights back. Missouri didn't hold back. In their official response, the state called out a massive contradiction in the Trump administration's legal position, and they did it with precision. Here's the issue. If the Department of Justice actually believes the Eighth Circuit made errors, then why fight against Supreme Court review? Missouri argues the only logical move would be to support review so those errors can be corrected at the top. Instead, the DOJ wants to block review and claim they'll clean it up later in the lower courts, and Missouri's not buying it. Their legal team laid out the real problem. The Eighth Circuit didn't just strike down a few provisions. It ruled the entire law unconstitutional based on its Second Amendment intent. That means the precedent now says a law can be invalidated just for being designed to protect gun rights. You can't fix that with a narrow Rule 60B motion at the district level. Why? Because lower courts are still bound by the higher court's reasoning. So even if the DOJ walks back a few parts, the damage is already done. That's why Missouri is pushing hard for the Supreme Court to step in, not just to clean up the Eighth Circuit's logic, but to draw a clear line around what states can and can't do when it comes to defending constitutional rights within their own borders. Trump administration's surprising move. After dragging their feet for months, the Trump administration finally dropped their response to Missouri's Supreme Court petition, and it threw everyone for a loop. Instead of the full-on support gun rights advocates were expecting, what we got was a carefully measured move that walks a tight legal line. The DOJ didn't back Missouri all the way, but they didn't reject them outright either. Their filing admits the district court may have gone too far, especially when it comes to blocking parts of Missouri's law that could have been protected under the anti-commandeering doctrine. That doctrine, for those who don't know, prevents the federal government from forcing states to enforce federal law. It's a solid constitutional shield, and the Trump DOJ knows it. But instead of pushing this argument at the Supreme Court, they're trying to keep it down in the lower courts, where they've got more control over how it plays out. It's a tactical retreat, one that avoids risking a nationwide precedent from the high court. In fact, they even said they wouldn't oppose a Rule 60B motion to scale back the injunction, basically admitting the original ruling was too aggressive. It's a big shift from the Biden administration's all-out attack on Missouri's law, But it's not the kind of legal defense most Second Amendment supporters expected from a Trump-led DOJ. The court battle timeline. This legal fight didn't land in the Supreme Court overnight. It's been a long and tactical battle. It all started when a district court in Missouri ruled against the state's Second Amendment Preservation Act, siding with the Biden administration and striking down the entire law. Missouri fired back fast, launching an appeal to the Eighth Circuit and filing an emergency application with the Supreme Court to keep the law in place during the appeals process. Their argument was simple. If the law stays blocked, the state and its citizens could suffer irreparable harm. But the High Court wasn't convinced. In a crushing 8-1 decision, the justices denied that emergency relief, with only Clarence Thomas standing behind Missouri. From there, the case bounced back to the Eighth Circuit, where oral arguments were fast-tracked. That court doubled down, affirming the district court's decision and once again wiping out Missouri's law from top to bottom. But here's the important detail. The Eighth Circuit didn't just go after the law's structure. Their reasoning focused squarely on the law's purpose, defending the Second Amendment. That distinction changes everything, because it sets a dangerous precedent, that a law designed to protect constitutional rights can be struck down just for why it exists, not how it functions. Missouri SAPA law breakdown. Back in 2021, Missouri passed what might be the boldest Second Amendment defense law in the country, the Second Amendment Preservation Act, better known as SAPA. This law doesn't just talk about resisting federal gun control, it builds a full legal wall inside the state to stop it. At its core, SAPA gives Missouri its own definition of Second Amendment protections and tells state officials they're not allowed to help federal agents enforce any gun laws that the state sees as unconstitutional. That includes police officers, state employees, and anyone acting in an official capacity. If the feds come knocking and Missouri says no, that's the end of it. But SAPA goes even further. It gives regular citizens the right to sue any Missouri official who breaks that rule, up to $50,000 per violation. That's a serious incentive for state employees to stay on the right side of the law, no matter who's in charge in Jefferson City. The law also forces state agencies to document every time federal authorities request help in a gun-related case, bringing transparency to every corner of federal enforcement activity inside Missouri's borders. This wasn't just a policy. It was designed to be a permanent shield, even if future governors or lawmakers go soft on gun rights. The shocking 8-1 decision. When the Supreme Court handed down its 8-1 emergency decision denying Missouri's request for a stay, it sent a jolt through the entire Second Amendment community. Justice Clarence Thomas stood alone. He was the only one who backed Missouri's position. Meanwhile, Chief Justice Roberts and the rest of the bench, including the conservative majority, all voted to shut the door. And that caught a lot of folks off guard. Given the court's recent moves in cases like Bruin and Heller, most legal watchers expected more backup for Missouri. Now, to be clear, this denial doesn't automatically mean the court will rule the same way if they hear the full case. But it does reveal something deeper. Right now, the justices clearly weren't convinced that Missouri would suffer irreparable harm just by having the law on hold during the appeal process. And more than that, this ruling hints at something bigger, a growing hesitation to let states completely disengage from federal enforcement, even if the law in question might overreach the Constitution. Justice Thomas's solo dissent shows that at least one member of the court believes this law deserves a full hearing, but it also proves just how steep the climb is for Missouri to secure the 4 votes it needs to get the case onto the court's docket. Supreme Court 8-1 emergency decision. This 8-1 ruling didn't just impact Missouri, it sent a message to every state in the country. The Supreme Court's emergency decision fundamentally shifted the battlefield for Second Amendment preservation laws. And this wasn't just about whether Missouri's law could stay in effect during the legal process. It was a signal, a warning, about how the court currently views state versus federal showdowns over constitutional rights. What's especially dangerous is the precedent it sets. The ruling didn't just validate the lower court's view of the law's mechanics. It endorsed the idea that a state law can be struck down based on legislative intent alone. Not what the law does, but why lawmakers passed it. That opens the floodgates for new federal challenges built on political motives instead of legal structure. And with the September 29th conference approaching fast, we're looking at a defining moment. Either the court agrees to hear Missouri's case and reasserts the boundaries of state sovereignty, or the door closes, and that window for resisting federal gun control narrows nationwide. However this plays out, one thing is clear. The rules around the Second Amendment are being rewritten in real time, and every gun owner needs to stay sharp and stay ready. Make sure you like, subscribe, and drop a comment down below. These legal battles are moving fast, and every update matters. Share this with every gun owner you know, and I'll catch you in the next video where we break down exactly what the court decides. Stay sharp.